Hello, everyone. We're happy to have LC here with us today. LC, thank you so much for joining us. How are you today?
I'm great. How are you?
I'm good, thank you. So, my first question, how did you get started in the blockchain and Web3 legal field?
That's a good question. I started basically out of curiosity. I was doing environmental law in South Florida, and I was a little burnt out on working for the government doing Everglades restoration. And there was a lot of events happening in Miami that were, crypto oriented or blockchain oriented, where founders of companies would be talking. So I just kind of went to see what it was about. And, you start chatting with people in the Web3 space, and they're very hands-on and very friendly. So I would talk to people and I'd be like, oh, I'm not a dev, I'm not a tech person, I'm just a lawyer. And they would immediately light up and be like, oh my gosh, you can read, can you help us like write this white paper, can you help with this, can you help with that, what do you think about this? So I just started jumping in and being very hands-on. And eventually my law firm found me, and I think they saw me speak somewhere, and then we got connected and they reached out, and I decided to jump ship and go full-time blockchain.
Okay, that's really interesting. And can you list some primary legal issues surrounding cryptocurrency?
The biggest thing is, the security aspect of it, like whether or not your token is a security under the US jurisdiction, the SEC, or maybe the CFTC. But even outside of the US, Europe with the MiCA regulations has some rules on how to finance the tokens. China has some rules on how to do it. So no matter what jurisdiction you're in, all the major players have opinions about whether or not that token is a security and how to navigate that accordingly. So I think that's probably the biggest bear of the crypto aspect. But even more than that is like understanding the money flow of things generally, understanding the partnerships of things. In the blockchain space, we have a lot of DAOs, or just collective concepts, where it's like, oh, well, us as a collective, we're building this open source thing, so there's no IP to own, or there's no this to worry about. And it's like, that's not necessarily true. Even if that's the ethos you're going for, there's generally stuff to protect, and an entity might be the better solution to protect that in some way. So I think it's a broader question of understanding startups, what you're building, how to protect it. But specifically for crypto, it's, understanding the financing and ensuring that the regulatory agencies are comfortable with what you're doing.
Okay, and what do you see as the most pressing regulatory challenge for cryptocurrencies?
Definitely the just understanding where the MiCA regulations are headed. Other jurisdictions will take that and run with it, or create offshoots of it, or mirror it in some way. How the SEC is going to approach crypto moving forward, how the CFTC is going to approach it. Basically any three-letter agency. That the IRS is kind of conceded to a lot of things, and they're just focused on ensuring they get their cut of the pie. But the other agencies, they're definitely focused on more control and more trying to narrow the path forward. But that's being litigated. So, the right judge could broaden that path and really open the doors for everybody, as we saw with the Ripple case. But that's such a low court, it'll be quite some time before we get true clarity and permanence on that decision. So it just getting that sort of regulatory clarity from those three-letter agencies from a US perspective, and then from an international perspective, seeing now that MiCA is in play, seeing where that goes and what iterations come from it, and then what other jurisdictions use what works about MiCA to, adopt, or what's not working to iterate on it. It'll be interesting to see the policy that comes out of these next few years, especially if we're back in a bull run, and especially with an election coming up in the US, how prevalent the conversation surrounding crypto becomes will be really telling for where the regulations are headed.
Okay, and can you tell me how does immutability of blockchain records impact legal disputes?
So we're starting to see some case law, a lot of legal courtroom issues come from proving veracity in evidence. So having an immutable chain might be easier to prove. You get someone up there and say, like, this is how the blockchain works and this is how the records are created, and you establish that line of fact. That might be a great way to prove veracity of records in a more efficient way or a more permanent way moving forward with evidentiary rules. So that's really helpful. But that's also people that build in this space think they can get away with a lot of stuff. But what they forget is, like, what they like about blockchain is it's immutable. So you have to remember, if you do something early on, even if you pivot later, you still have this really permanent record of whatever it is you've done. And that cuts both ways. So people need to remember that. But I think in terms of accepting evidence in court, it should be helpful in the long run, as soon as we, find an efficient way or a way to explain it to a judge, like, hey, this is how this is created and this is trustworthy, and that actually helps things.
Okay, and how do you stay updated with the constantly evolving legal landscape of blockchain and Web3?
Oh, it's a lot of reading. But I mean, lawyers are used, so it's just a continuous amount of reading. And honestly, I stay up to date because I attend a lot of conferences, so I'm kind of perpetually on the road. I was in ECC, and then I was in Budapest, connecting with some blockchain people there, and then Lisbon, connecting with that great digital nomad community there. I'll be back at ETH Milan speaking at that event, and then I'll probably stay in Europe for the events that are in November or October or November maybe. So I find it helpful to attend events. I usually stay with like a hacker house, so I'm with devs and I'm understanding not just the legal stuff that I keep track of through, like, there's a lawyer Telegram group, there's like a few that we just keep the conversation going, and we're constantly touching base on the cases that are out there, and also having internal conversations for how to push things forward. There's groups like LexPunk and LexDAO that are proactive. There's the Blockchain Lawyers group that's very proactive in terms of like policy and legislation. So the more you can stay in touch with those groups, the more you can kind of keep an eye on the developments. But I also think it's just as important to stay with the actual developers in the space, which is why when I attend these conferences, I try and connect with builders and stay at hacker houses and connect with the communities that way. And for ETH Denver, I participated in the hackathon for that. So learning about ZK proof was very hands-on for me, which was, I think, super helpful ultimately.
Okay, and can you tell me that are there any similarities between like traditional contract law and smart contracts?
Yeah, so smart contracts are, code at some point. They're code that could capture a contract that's been negotiated. They're code that maybe are something that executes because of a contract that's negotiated. But I think to think of a smart contract as truly just more code oriented than actually the contract itself. It's not really a legal term. It's not a legal contract. There are some cases where it could be. You could write a legal contract into the code and then have it execute accordingly. But I think smart contracts facilitate legal contracts in a lot of ways, or sometimes just have nothing to do. Maybe, the code is just separate and it's the platform in which the people communicate for the executing or the, drafting of the contract. So I think having them be two separate concepts, I know the Tornado Cash decision, the judge tried to grapple with that, and the language of that case shows how complicated it can be and how confusing some of these terms can be. I even think, Vitalik said something about he regrets naming it a smart contract because it's confusing. So I think language matters, but having it more in the concept of smart contract is good, and a contract is, a legally enforceable agreement, are kind of two separate concepts that until we start seeing, self-directed or self-executing smart contract, legal contract agreement code, I think they're just going to remain kind of two separate things. But they do get intertwined, as we saw in the Tornado Cash case, and it can get really sticky. So the facts matter and how things operate. No matter, I mean, in law, a lot of it isn't what you call it, it's how it operates as. So really understanding what the tech is doing is really important no matter what you call it.
Okay, and let's talk about cases. How would you handle a case where the anonymous nature of a blockchain transaction is being challenged in court?
Well, I mean, the Uki DAO is a great example, where the DAO agreed, I guess, internally to just not acknowledge that they were being tapped in some respects. And because of that, they got a default judgment against them. But in practice, how do you enforce the default judgment when you don't know who any of the players are? So to the extent that they can remain anonymous, they're kind of in this just in between waiting. They're in like a waiting zone where it's like, this decision's definitely against them and it's not really appealable because they didn't respond, but they also aren't really identified yet. Is that a good approach? It's really hard to say. If all the Uki DAO members if none of them are within the US jurisdiction, like if none of them can be touched by the US jurisdiction or arguably, pulled into the US jurisdiction, then it's maybe a good idea. But if you're being sued, it might not be the best idea to just ignore it and wait for that default judgment to go. I mean, every court in every jurisdiction has very specific rules for how to respond and ensuring correct service. So I think they definitely chose a very specific path, and I'm sure they had a legal person on the team working with them, and they have reasons for why they did what they did. It'll be interesting to see how that develops and whether or not that pays off in the long run. But anonymity and the law don't go well together. The law wants to know who you are. And in any jurisdiction, US, aside, every jurisdiction wants to know. Ultimately, it comes down to money. So they want to know who is controlling the money that's flowing. And that jurisdiction, wherever you are, you can be in the Seychelles or Europe or Asia, every jurisdiction wants to know who is in control of the money that's flowing, that's shared among a group of people. And that's what this all comes down to, is finding a way to dox enough of yourself so that a jurisdiction is comfortable with you operating in their jurisdiction and they have someone responsible when something goes wrong.
And if a DAO commits a regulatory breach, who is legally responsible?
Well, I'm going to give you like the most lawyer answer, which is it depends. But it really does depend, because does that DAO have a legal wrapper of some kind? Does that DAO, if it doesn't have a legal wrapper, it might be an unincorporated association. What does that mean? Is there identifiably like a group within the DAO that's like mind and management, or is it truly like everyone's on the same level and everyone's jointly and severally liable for everything? But it really depends why having a document that captures the meaning of the minds that the group has, meaning we are a group of 10 people and we take equal responsibility, or we're a group of 10 people, but these two are who control the purse, the multi-sig. These two people are ultimately just a smidge more responsible, and having that memorialized in writing, anything is helpful, because if everything's going smoothly and you're following all the laws, no one's really noticing, right? But the moment there's friction, is the moment you need all of this already resolved. So it's important to resolve these things before the friction comes. When everyone's thinking clearly, everything's going smoothly, it's important to think through a procedure for what happens when things aren't going smoothly. You don't have to decide what happens when things go wrong. You have to decide a procedure for when things go wrong. And that's to say, well, when things go wrong, these two are the mind and management, or these 10 are the mind and management, or we're all equal and it's a majority vote. You just need some sort of agreement in writing that addresses a procedure for when things go wrong.
Okay, and have you ever faced ethical dilemmas while representing clients in the blockchain and Web3 industry?
Yeah, I would say, in any emerging tech, you're pushing the bounds. And what's frustrating about government and bureaucracy is that the government is really slow. So a lot of times people will come to you and say, I have this great idea, I want to change the world in this way, or I want to do, this or that. And it might be in direct conflict with the laws that exist that aren't in a gray area. And while those laws are archaic or really, lacking forethought or just wrong if you think they're wrong, it doesn't, there comes a point where as lawyers, we're the last line of defense for bad actors. So we have to walk this tight line of saying, yes, this is a gray area. This is something we can push forward. Or like, if we just do a little bit more homework, here's a creative path forward that still follows the spirit of these regulations and uses these and makes this tapestry of something that could be effective, or like an approach that the government would appreciate. But if there's definitely a conflict to the extent that we're saying that's just not, I don't have a good feeling about that, or I don't feel safe, that, this is keeping me up at night because there's really no path forward here. What you're trying to do is blatantly against these regulations. That's when you have to say, as lawyers, we're the last line of defense for bad actors. And we have to say, like, this is not okay. And I cannot continue representing you. And that's happened, a couple times over the years, but generally people aren't trying to be, they're trying to push this forward. They're trying to, create new solutions to problems, and the regulations are navigable in some ways, and they're open to how to navigate that properly. But so it's not that often, but there have been a couple cases where we've just had to say, well, we no longer feel comfortable representing you. And, this is our line in the sand, because we have to protect where we stand,
Yeah, wow, that's pretty interesting. Were there any instances where you had to drop a client due to their unethical practices in the blockchain space?
Yeah, I would say whenever they pass that line, where we're just not comfortable, like a lot of, there's a lot of paths forward, like onshore, offshore, and ensuring the proper documentation. But there's some things that are really hard to do with pooling specifically. In most jurisdictions, there's like some things that are just blatantly, every jurisdiction is like, yeah, this is just not doable. So in those scenarios, it's harder to continue representing when a client's like just not listening and they're not receptive. I mean, we can't make decisions for the client. We can only advise and say, this is legal and this isn't. But at a certain point, if you're continually advising like this is not doable, then we have to separate ourselves and no longer represent them.
Okay, and I have two last questions for you. The first one is I'm really interested to find out, did you jump into blockchain law field because of its lucrative prospect, or do you genuinely believe in the technology potential?
Well, I mean, I am a millennial, so I'm always trying to pay off my student loans perpetually. But I do say, when people, especially people that don't really know the tech industry, they're like, oh, so you're a Bitcoin lawyer, you're like a crypto lawyer. I always try and clarify it and say I'm a blockchain lawyer because I believe in the underlying tech. Like crypto might, that token that you're holding onto and hoping that Elon keeps tweeting about, that token might not go anywhere, right? But the underlying tech that serves the crypto industry, I really think that is where the future is. I think in seeing how Facebook and Google are competing for being the master logins for every website you interact with, blockchain can change that, because that idea of a digital wallet being your identity, I think that's obviously, we're already there. If Facebook and Google are trying to be that identity, having an immutable record, on chain is the next logical step for that future that Google and Facebook are already fighting for. So that's just one use case. Once you add in ZK proofs and like healthcare industry and how to leverage where this technology is heading for what the problems are now that can be solved with this, it seems apparent to me that blockchain really is not going anywhere, and the tech, as it keeps building stronger with more practical impacts and use cases, it just seems like a logical step for me, and I was happy to jump ship for it.
All right. And last but not least, how do you anticipate regulations evolving in the next 5 years for the blockchain?
I think we'll get a lot of decisions from various places. A lot of case law in the US will create the legislation that seems to be lacking from our legislative body. Make any real change happens. Now, the right presidential candidate could come in and change that, all of a sudden be super pro crypto. I know the mayor of Miami, who accepts his salary in Bitcoin, he is running for president. He put his hat in the ring. Okay. So maybe he gets elected and creates like an emerging tech division for pushing forward positive regulation that allows for certain things to happen. That would be, crazier things have happened with the US election. So here's rooting for that. But without that, I think you'll see a lot of case law create precedent, which is terrible. Anytime you have the judiciary creating law, basically through decisions, leads to very poor laws, because you have uneducated judges who are learning on the fly from briefs, and with a really tech heavy lift can be a lot to ask of a judge who's maybe only done like civil litigation and maybe isn't so savvy on this tech. So it can lead to some rough precedents. But with Coinbase and the legal teams we're seeing out there fighting really hard this battle for thoughtful momentum for the space, I think we have a good shot. But definitely a lot of cases are going to come down. The SEC has been very aggressive about handing out complaints and going after certain bad actors. So you'll see the dramatic cases first, the worst bad actors, the most egregious, because those are the slam dunks and the things that set those initial lines in the sand that say like the buck stops here, right? But eventually you'll see more nuanced cases where it really starts to create true binding rules for how to move forward in a space. And those will be interesting to watch and see how they develop. The MiCA regulations that are in place in Europe will definitely get iterated upon as companies start building, and as the legislatures see the money coming. I mean, we're starting to see companies leave the US and go to other jurisdictions. Switzerland, like Zug, Switzerland is like the Silicon Valley of blockchain companies. It's like a huge headquarters of just like so many, because it is such a friendly place. And if you can afford it, the problem is it is kind of expensive to get there. But if you can afford it, it seems like a really great place to be right now. And so maybe, they'll create a little bit more incentives and bring more companies there. I know there's a lot of crypto companies in Lisbon, and there's a lot of incentive to move there. So as you start to see the shift, it's 2023. It's never been easier to not be in the US or to be somewhere else. So as you start to see these companies crunch their budgets and say, hey, it's just not financially smart for us to be in this place right now. Why don't we just shift to this place that's super friendly and super helpful? I think you'll see that jurisdiction start to see the financial incentive of having them there and create even more positive regulations for them to continue being there.
All right. Thank you so much, Elsie, for this interview. It was really interesting and pleasant to talk to you today. Thank you so much, Elsie, again, and I wish you a good day. Have a good day. Yeah.
You too. Bye.
Thank you. Bye-bye.